If a defendant raises a Confrontation Clause issue only in the context of a trial order of dismissal motion, is that properly preserved? To find out, you have to read People versus Xavier Bacon, but it's 21 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Xavier Bacon. The citation for this case is 2025 New York Slip Opinion 03692, published by the New York Court of Appeals on June 18th of 2025. The issue in this case is whether a Confrontation Clause violation is properly preserved when it's raised in the context of a trial order of dismissal motion at the close of the people's evidence. To understand and appreciate the context of this case, what's helpful to know, the two parts of the law that's helpful to know as background, is first that is the concept of preservation. The preservation doctrine, which is codified in criminal procedure law 470.05, it says that a question of law is preserved for appellate review only where a protest to the alleged error is made at the trial court at a time when the trial court judge could address the issue on the merits, can correct it, and where the court expressly decides the question raised on appeal. You can't fail to raise an issue at the trial court level and then raise it at the appellate division or the court of appeals. The answer that you'll get back is that this question is not properly preserved, and you can't raise that appeal. So preservation doctrine. The second thing you have to know is that under CPL 290.10, at the close of the people's evidence, right? So the prosecution presents their case, and then they say, at this point, the people rest. Once the people rest, they're not introducing any further evidence in support of their case. At that point, the defendant, basically the defense counsel, always makes a motion for a trial order of dismissal under 290.10, which basically the argument here is that on the basis of the evidence presented, no reasonable fact finder could deduce or infer that the elements of the conviction have been satisfied beyond a reasonable doubt. And then you make an argument as to why the evidence is insufficient. And then the judge either will grant it, deny it, or reserve. But that's a trial order of dismissal motion, which is based upon the insufficiency of the evidence. Okay. What are the facts in this case? The facts are that the defendant, Xavier Bacon, was indicted and charged with several charges stemming from an assault on two individuals at a subway station in Manhattan. The defendant and a co-defendant were tried on various counts of robbery. And the allegedly what happened in the subway or in the actual crime was that these two victims were attacked and robbed, and the defendants got away. And the victims then told the police officers who responded what had happened to them, gave descriptions, gave certain information to the police officers, which they then used, and ultimately the defendants were apprehended and tried, right? How the evidence actually against the defendants are not important with respect to that, other than the fact that the victims informed the police officers. The entire trial, the prosecutor kept saying, we are going to call the police officers and the victims. They called the police officers, they introduced other evidence, and then they never called the victims. They kept saying, we're going to call the victims tomorrow, we're going to call the victims a week from now, then tomorrow, whatever it was. And ultimately at the end, the people just said, we rest, having not called the victims. At that point, under 290.10, the defense counsel made a motion to dismiss on the basis of a trial order of dismissal, saying the evidence is insufficient. And in the context of that argument of the trial order of dismissal, defense counsel said, on behalf of Xavier Bacon, I never got a chance to cross-examine these victims, these eyewitnesses who informed the police officers, and the police officers testified about what happened at the trial. And I was deprived of that right to cross-examine the victims. And I could have shown the jury, the fact finder here, that the victims were on methadone, that they could have been impaired, that their abilities to remember, to recall, to relate what happened to them, to perceive events could have been impaired by the methadone that the victims were on, or the victim was on. The judge clarified that this was in the context of a trial order of dismissal, and denied the application. Ultimately, or I think maybe reserved it. The jury convicted the defendant, and the judge then revisited the decision and said, I'm denying the application for a trial order of dismissal. And then on appeal, the defendant raised as an appellate issue the Confrontation Clause violation, the concept that in New York and in the country, actually, it's under constitutional issue, a United States constitutional issue, you have a right to confront the accusers against you. And we don't allow witnesses to testify without being confronted, without going through the crucible of cross-examination, as we say. But when the defendant raised this issue on appeal, the prosecution, the people in opposition said this was never properly preserved. There was no motion to dismiss on the basis of Confrontation Clause violation. And that's what goes up to the appellate division. The appellate division affirmed the conviction, said the defendant did not properly preserve it, goes to the Court of Appeals. And here we have a 4-3 split. The majority here, the 4 judges in the majority, say this was not properly preserved. The motion is not properly preserved when it's raised in the context of a trial order dismissal 290-10 motion. They said the defendant failed to preserve his claim that his constitutional right to confront the witnesses against him at trial was violated. He did not raise the constitutional challenge that he now presses before the court. And basically the concept is the judge never had a chance to rule on the Confrontation Clause issue, the trial judge. So it's not fair to reverse the trial judge on a decision he didn't make. But there is a strongly worded dissent by, I believe it was by Judge Rivera, explaining how in the case law, as long as you raise the argument, it's considered preserved. And here the argument was raised, even though it was in the context of a trial order dismissal. But once again, the holding here from the majority, the controlling holding here, is that it is not sufficient when raised in the context and in the arguments of a trial order dismissal motion. It's got to be raised separately, or at least the judge has to be alerted to the fact that this is a separate application with respect to the Confrontation Clause violation, not just a TOD argument. And that's the case of People versus Xavier Bacon. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.